we are the Office of the Juvenile Defender. And there's Terry, and I believe you probably know Terry. Everybody knows Terry.
Yeah, once or twice.
Okay. If you're not super familiar with us, so we've been around since 2005. We are part of the IDS family, sort of like public defender offices, the capital defender, the appellate defender. And we historically have been largely a resource unit, which what that means is we provide training and technical support to attorneys and largely have done that. As you can see from our mission, we also do some direct representation. Terry, of course, in Statesville and in Taylorsville. Yolanda's out in Asheville, and she is just now starting to take some cases in her area. We also work hard to try to make sure that any given county has like appropriate defense delivery services. Every county is different in North Carolina, and we try to sort of do best, for that county. For example, of course, in Ardell, Alexander, there is a public defender's office, but they don't do juvenile because Terry's there and there's two contractors. We also, work to encourage people to do the work. I think, as everybody knows, there's been, in recent years, lack of attorneys doing indigent defense generally, and we just try to encourage folks to specifically take on juvenile defense. And we work to, change the system where we can. All right. So I think folks know this, but sometimes we get questions. So I just want to sort of go over. Oh, I'm sorry. Forgot to share my screen. I've been talking the whole time. Look at that. Give me just 1 second. Sorry about that. All right. Sorry. Here we go. Is that?
I'm confused.
Oh, I'm sorry. We should have said, I only do 1,000 trainings a year. My apologies. But that other stuff wasn't as important. All right. Here's sort of the substance of what we're going to discuss. So how are these cases currently being appointed? And what's our approach to starting appointment? All right. So when we talk about which cases, we are just talking about youth charged with first-degree murder. And so in North Carolina, this is largely premeditation, deliberation, or murder committed during the commission of another felony. Those are the offenses we are discussing. It's very narrow. I know that in some juvenile cases, sometimes the complaint and the petition looks like maybe second-degree murder, but it's actually first. And so what we have determined is, if there's a question about it, still let our office know, and we'll be glad to work with folks and figure it out. I think, as most folks know, youth under the age of 18 have not been subject to the death penalty since 2005. So therefore, the Office of the Capital Defender does not appoint counsel in these cases. And that's only been really since March of 2005. So how has this been working? Well, it's been working locally. Every county should have a local list of attorneys that they can appoint from, sometimes referred to as the high-level felony list. But just to reiterate, not going through the Office of the Capital Defender. It's not a big deal. OCD will let us know if they get somebody, and we'll work to figure that out. So we have a very good working relationship with them. So one question might be, why now? Why is the Office of the Juvenile Defender, which for the first 20 years was not involved in direct appointment at all, why are we doing it now? And this really started after the pandemic and into the sort of the first year or so when Raise the Age was implemented. that what we were seeing first off was there were more than one attorney appointed in a case. So that could create some instability with representation. Sometimes the attorney was more familiar with the juvenile side, sometimes more familiar with the adult side. And so we felt like combining the two was sort of in our client's best interest. And, you know, it just some of these attorneys, they knew more about what was going on in one court than the other. So that's really how this got started. We wanted to make sure that there was consistent representation for these youth that were possibly facing life in prison without parole. And as I mentioned before, there has been increasingly a lack of attorneys handling high-level felonies. So where we landed on this was we decided to, again, sort of model what was already out there, the Office of the Capital Defender, and to create a standalone roster to handle these cases. Again, and I'll talk a little bit more about it, but we are only talking about 13, 14, and 15-year-olds in juvenile court charged with first-degree murder, or 16 and 17-year-olds charged in adult criminal court with first-degree murder. And so we set up basically from scratch an entirely new policy to approve these attorneys, an application process, and to be appointed. And again, thank you, Office of the Capital Defender, because we got a lot of suggestions and templates from them. Now, these are the counties where the process will begin. Why only these counties? Well, there's a few reasons for that. One, we thought it made sense to try it out in certain counties and kind of work out any issues that might arise. Everybody's familiar with e-courts and kind of how that was laid out. We thought that was a pretty good idea to do it in parts. Why these counties? So my policy decision was that we needed at least 3 available attorneys per county at any given time. And the reason for that is because, as you all may have experienced in your work in the court system, there are many times when youth are involved in these crimes, there is more than one. And so we just thought it would make more sense to have some level of a buffer, so we have a minimum of 3 attorneys available in any county at any given time. The other piece of this I would like to mention, and I'll bring up the map in a second, is that we had talked to the public defenders, and some of the public defender offices were interested in still being the appointment authority in their jurisdictions. And so what we landed on was kind of an opt-in, opt-out process where the chief public defender could determine whether or not they wanted to be part of the system or not. And that's sort of what we've got right now. And that's why we've got those particular counties. And this is just another visual description, depiction of where we're going. As you notice, it's kind of the central Piedmont area of North Carolina. And as I just mentioned, you can see in this gray area here, these are public defender offices that have opted out of our appointing attorneys in these cases. Now, I did want to say also that even though we are not appointing in these counties, we have already been doing this, that we have been helping jurisdictions find attorneys. So even if we're not officially directly appointing attorneys in these cases, we are still assisting in trying to find lawyers. And then, again, just to throw out an example, let's say Guilford County Chief Public Defender Jennifer Ryerson, might have a situation where there's multiple youth charged or combination of youth and adults, and they can't find enough attorneys. Jennifer may reach out to us and we would help them find an attorney, and then the public defender would appoint. So I just wanted to point that out. Okay. So, like I mentioned before, we have created on our website an application process, very much mirrors the Capitol Defender. We also, incidentally, if you have already been qualified for the Capitol Defender list, we have a lot of the same criteria. They check that, but they also have to have juvenile delinquency knowledge and experience. I think, as a lot of you know, even when the 16 and 17-year-olds for these and the highest level offenses were put back in the adult system for offenses committed on or after December 1st, 2024, they can still be removed back to juvenile court. So we want to make sure that the attorneys have the experience and knowledge for both. So, okay, how do we imagine this working? So because many of these juveniles and these youth will be in confinement, and if they're under 18, they will be in a juvenile detention center, but some will be under a secret custody order, some will be under arrest, that the judge would appoint somebody immediately and then sign the notice and determination of counsel, which would be sent to us, and also a copy of the petition or warrant. And you can send this information to us two ways. We created, and I'll explain why. So OJD notice at nccourts.org is a mailbox that our staff has access to, and we will be checking it every day, several times a day, to make sure we're covering it. We included the eFax line as well, because that's a little bit more secure. And if you all feel more comfortable using that because it's confidential information, use that. Again, we will check that as well. And then we will go on to eFile and file and serve the order of appointment. So let me just pause there for a second and see if there's any questions. Okay?
So far, so good.
Thank you. All right, so going into a little bit of detail, again, because these youth are probably locked up, go ahead and appoint a local lawyer. Notice that it could very well be that the provisional counsel will ultimately be their lawyer for the entire process. That's perfectly fine. We'll figure that out. But we did this so, they need lawyers immediately, and it would just be easier on the front end, in the immediate need. We're very familiar, of course, with juvenile court. You're going to have a secure custody hearing within 5 days, and you'll need to appoint somebody, and then the first appearance within 48 hours for the youth/adult client. Already mentioned notice and determination of counsel. Also, while we're here, I wanted to give a shout out to AOC and especially the Office of General Counsel, very patient with us in creating these new forms. And they will make these available online. We gave them the date of March 30th for cases on or after that date. So those will be available to everyone. And this is kind of what it looks like. Again, we used the existing forms to make these, so hopefully they will look familiar, and hopefully they will be as easy as possible to utilize. We were not trying to reinvent the wheel. We were trying to use materials, forms that were already available. So again, these two ways to get the information to us. And if you could also send us the next court date, whoever is provisional counsel, and the copy of the petition or warrant. And just also be aware that we are also very mindful of confidentiality for any of the 13, 14, or 15-year-olds coming. So we will make sure that will stay in our information and will only be released to the necessary parties. And at that point, we will seek out counsel. This is going to be our office's priority. Like I said, we are monitoring the e-fax line and the email address, the inbox, and we will be as quick as we can to find counsel, hopefully within 48 hours, and then we will sign the order of appointment and send via file and serve. Just last week, Terry and I, to sort of get up to speed, met with some of the administrative staff at the Office of the Appellate Defender. Very helpful. I think we will, in addition to filing and serving the notice of appointment, we are also going to email this information to the clerk to just sort of make sure, sort of double up the information, make sure everybody's got it. So hopefully that will assist in the process. And that is what the 447 will look like. And again, everybody will have access to these forms. So we just thought we would throw out a few questions. Again, one of the aspects of the representation we were trying to fix was, does a new attorney have to be reappointed after the case is transferred? And no, they do not. There may be some judges who may want to say in court, I'm reappointing, attorney A or attorney B. That's fine, but it does not have to come back to us. Once that attorney is appointed in adult criminal court, they stay, but specifically in juvenile delinquency court, once the case is transferred, they are still the attorney of record. And that should not change. But again, if there's any question about that, always feel free to call us, email, and we'll be glad to answer. There will be some times where the judge may go ahead and appoint somebody who is not on our roster. That's fine. If there's a question or issue, or if you could think about letting us know, just let us know. We know that this happens in other contexts. And we'll be glad to support that lawyer as well. But if there's any issue with that, again, feel free to reach out. So if there are other charges pending, unrelated charges, maybe some charges in another county, we are going to work the hardest we can to figure this out and make sure as best we can that the one attorney will handle as much as they can about this one client. I know this already happens, of course, in the real world, but we will be cognizant of it and try to make sure as best we can there's one attorney, one client, all charges, and we will figure that out with the attorney. So we, of course, are in touch with our roster, and if they find that there is a non-waivable conflict, they are supposed to file a motion withdraw and then notice us, and we will go back and reappoint. If they think that the conflict might be waivable, we will talk to them, or we will suggest they talk to the state bar. But we are cognizant of that, and we will work that out with them. So here is another part of the process that may alleviate some work on your part. Just like with the Office of the Capitol Defender, they will submit a fee app directly to our office. AOC J448, I think I have a picture. And so they put their hours. We are hoping they will do interim fee apps. I know that's probably a little bit maybe beyond y'all's interest, but we're trying to get them, to give us as much information as we can so, our agency can be fiscally responsible. The case and the payment will come back to the court through recoupment. And we're working with IDS on that process. That's when the case is over. I think as folks know, these cases can take a long time, even years. And that the other little quirk I would say about this is that recoupment in delinquency court and adult criminal court is different. Because like in juvenile court, the parents could be responsible to pay if the case is finalized in juvenile court. But we are aware of all this. It is, there are actually different recoupment forms on the 448, one for juvenile court and one for adult criminal court. I hope we've covered those bases. But again, we're all learning together, so we'll be able to address things if there's a question. And just to make sure everybody knows that it is $100 an hour for any of these cases. Whether you're 13, start juvenile court, whether you're 16, 17, start adult criminal court, it is $100 an hour. The other change is that, and again, this doesn't directly necessarily involve you, but for your information, when they seek expert funds, they will not go to the judge ex parte. They will come to our office. We have internal forms for that, and we will approve expert funds. We will send that back to the attorney. The attorney will then be in communication with the expert and be monitoring the expert. And then when the expert is ready to get paid, they will bill IDS, just like really it's done now. The only difference here is that the approval for funds will run through our office, but more or less the payment of experts will still be through IDS, just as it's happening for high-level felonies today. All right, so I probably should change that date. It's actually March the 30th, but I'm saying it out loud on this presentation. We just moved it back a week because we had to do some more internal operations here, but it will be for offenses committed on or after March the 30th. Here is our office, but basically that is it from our end, but I will be glad to stay on and answer any questions that folks may have. Yes. So we are going to, after we record it, we will send it back out to that initial email to all of the elected clerks, and everybody will have a copy of this. Good question. All right. Well, did I stop sharing? All right, good. All right. Well, thank you, everyone. Just again, for your information, let me make sure I have the correct date. That for any of your deputy or assistant clerks, we are going to be doing the same presentation. It will be Friday the 13th. That sounds more ominous than it is, and will be at 12 o'clock. You all got the information for that, but we will remember to resend that out, and really anyone from your staff, yourselves or your staff, feel free to join. We're also going to have sort of a broad stakeholder training for anybody involved on the 25th, but we wanted to make sure that there was a specific training for your staff on the 13th. So please, anybody who wants to show up to that from your offices are more than welcome to join. All right. Well,
All right.
thank you for coming. And any other questions, comments before we wrap up?
Anything? We're good.
All right. That's news. That's very positive to our ears. Thank you. All right. Well, thanks everyone. You are always welcome to contact us anytime with any questions. Again, we're all sort of doing this together, but I very much appreciate you all being here and working with us on this project. Thank you.
Thank you.
All right. Y'all have a great rest of your day.
All right.